Greetings to everyone present. My name is Ankit Malhotra. I am the co-founder and president of the Jindal Society of International Law. Today amongst us we have titans, we have saviors, and we have glorious fighters of the armed forces from across the globe. It is indeed an honor and a privilege for the Jindal Society of International Law to be able to host them for this most valuable discussion. But before I proceed any further, I'd like to share a few words about the Jindal Society of International Law, which is a student-led initiative under the aegis of the Center for the Study of United Nations, under the expert guidance of faculty coordinator Professor Dr. Weston Popowski. We were founded in 2020 on the 18th day of November, and the launch address was given by Professor Dr. Jose Alvarez of New York University, along with the Vice Chancellor of the University, Professor Dr. C. Rajkumar, and a dear friend of the Society, Professor Dr. Mohan Kumar. The purpose of this society is to increase the student interaction with subject matter of international law through its various initiatives. Rather than being primarily research driven, we intend to offer a host of experiences and contributions towards skill building, thereby increasing the knowledge database available to the students. The society is an attempt to bridge the lacuna by streamlining resources and inculcating an overall interest in the vast expanses of international law. However, the spring series of 2022, entitled The Colloquium on Challenges to Global Governance and Humanities in the 21st Century, offers a compendium of scholarship from the academy and professional experiences from the bar. Over the past year, the Jindal Society of International Law has hosted around 100 speakers from the United Nations, International Law Commission, World Bank, and the Hague Academy of International Law. Through our previous series, we endeavored to study the different contours of international law through the speakers who covered and addressed the respective areas of expertise based on their years of research and practice. Given the vast ecosystem of international law and humanities, the society aimed to study the fragmentation and fertilization of the various disciplines in public and private international law. Thus, as a result, in this spring lecture series, it is important for us to understand the law and its challenges from broader, different, and differing vantage points. Acknowledging international law as the creation of states is also important to understand and appreciate the social sciences and humanities that have played a key role in shaping the law. Thus, a broader study becomes crucial and also critical. Through this series, it is hoped that one will develop a deeper understanding of Philip Jesup's magnum opus, A Modern Law of Nations, an introduction. So long as the international community of states is composed, it is only through an exercise of their will, as expressed by treaty or agreement, or as laid down by international authority, deriving its power from states, the rule of law becomes binding. As this international order is being tested, we must recover hope in it and also discuss aspects which are most important to the armed forces, which play an integral role in protecting state sovereignty and respecting these disciplines created by mankind. To do this and to discuss the global military landmarks, we today have a stellar collection of this constellation of stars amongst us who discuss their big book, which I hold up with immense pride and joy, as I enjoyed reading this so thoroughly. It is such a vivid account of military capabilities and also the legal discussions of this. The editors of the book are Mr. Navdeep Singh. Navdeep Singh is a practicing lawyer in the Punjab and Haryana High Courts in Chandigarh. He is the president of the Armed Forces Tribunal Bar Association at Chandigarh. He's also been a national service volunteer-reservist with the Territorial Army in the rank of major in the past. The Territorial Army is a unique force of volunteers while carrying on their civil vocations wear the uniform for a few days in a year during their spare time in peace so that they can bear arms for the nation's defense during war and national emergencies. He has been decorated with a record number of 11 commendations from the Army, Air Force, and tri-services institutions for his work for the military community and veterans and other issues confronting the defense services. He has also been operationally deployed, including voluntary counterinsurgency operations during vacation periods of the High Courts. Next amongst us, we also have Professor Franklin Rosenblatt, who teaches law at the Mississippi College School of Law in Jacksonville, where his scholarship focuses on criminal law. He is a retired judge advocate from the United States Army, where he served for 20 years and attained the rank of lieutenant colonel. After his military service, he joined the litigation department at a major law firm where he headed the firm's military and national security law practice group. He remains active in military cases as a practicing lawyer, amicus brief writer, and scholar. While with the U.S. Army, he served in 4 of the Army's 11 combat divisions as well as 2 special operation units. He participated in numerous military operations around the globe, including the Balkans, Southwest Asia, and Southeast Asia. We also have amongst us Eugene R Fidel, who's an adjunct professor at NYU Law School, a senior research scholar at Yale Law School, and counsel at the Washington, D.C. firm Platzman Trucker Lifer Fidel LLP. He graduated from Queens College and Harvard Law School and served as a judge and advocate in the U.S. Coast Guard. In addition, he graduated with honors from the Naval Justice School and has presented personnel in every branch of the armed forces as well as the commissioned corps of the U.S. Public Health Service and National Oceanic and Atmospheric Administration. We also have amongst us Jan Peter Spijk, who is the Netherlands Royal Military Academy graduate, a Brigadier General. Jan Peter Spijk read Constitution Law at Leiden University and graduated cum laude in 1990. Having gained experience in the field of operational law and personnel policy, he was promoted to Brigadier General in 2004 and appointed the Director Personnel Policy at the Ministry of Defense in The Hague. In 2006, General Spijk was posted to Kabul, Afghanistan as Netherlands contingent commander. In 2007, he completed the Royal College for Defence Studies and read International Studies at King's College London. Subsequently, he was appointed to the Director Personnel Policy at NATO's Allied Command Operations. In 2010, he was appointed as the TJAG of the Netherlands Armed Forces and senior military judge in the Military Chamber of Court of Appeals. From 2012 to 18, he was president of the International Society for Military Law and the Law of War. He was elected an honorary president in 2018. Currently, he is a member of the Society's Board of Directors, the Council of International Institute for Humanitarian Law, San Remo, Italy, and chair of the Netherlands Military Law Review Editorial Board. We also have amongst us Lieutenant General A.K. Singh, who is the former Lieutenant Governor of the Andaman and Nicobar Islands, is the ex-officer commanding-in-chief of the Southern Command, and alumnus of the National Defense Academy, which was commissioned into one of the oldest regiments in the 7th Light Cavalry on the 17th of June 1973. After a distinguished career and long service in the armed forces, he retired and was entrusted with the responsibility of the administrator of the Lieutenant Governor of the Andaman and Nicobar Islands. He took over as the 11th Governor General of Andaman and Nicobar Islands on the 8th day of July 2013. He now teaches an excellent coach and a tutor on the military studies, of which I have had the honor of attending and also participating. I was also responsible for turning in a 5,000-piece essay on the South China Sea dispute because of my growing interest in the subject and also because of its expert teachings. I welcome all our speakers and welcome the editors of this book to share their thoughts and encouragement for undertaking this task. Thank you.
All right. Thank you, Ankit, and thank you to all of the organizers for this event. I'm Professor Frank Rosenblatt. I worked with Navdeep and who came up with the idea to write this book. March to Justice is a book about a movement, a global movement. And, we've seen other movements like the international human rights law movement, where people from different countries and different backgrounds come together and they find some things that they have in common. So in a bit of a sleepier cul-de-sac of global movements would be the movement within military law. We found, worked with 25 authors and people who largely viewed military law as something to be, that was important, that deserved consideration, and that bore heavily on democratic values within their country. So the military justice system, what are the features of this movement that we talked about? One is that the military justice system is and should be a full partner with national civilian courts in administering justice for matters within its competence, and it should not reach beyond its competence. Another is that military law reflects what militaries and democracies are as inclusive institutions. Soldiers from Boston and Boise serve together. Soldiers from Winnipeg and Toronto serve together. Soldiers from Calcutta and Chandigarh serve together. The military is and proper military law is an ideal source of promoting national civics and unity. Another principle of this is that we want national militaries to be disciplined. There should be no accountability gaps when crimes are committed. When military members are deployed, we especially want a system that can hold them accountable for criminal acts, which might tend to undermine mission effectiveness. Within this movement, we also see and appreciate that certain aspects of justice are indispensable. These reflect the values of a democracy. And one of these is judicial independence. Those participants in the military justice process must be impervious to outside influence and interference. Courts should be impartial. Judges and prosecutors should not be susceptible to outside pressure. A military justice system must have the trust of the public. This purpose cannot be affected if the military justice system is shrouded in excessive secrecy. But moreover, our military law movement reveals some common ground about the rights of military members. Certainly when someone puts on a uniform, they don't get to enjoy all the freedoms and privileges that others have. With military service comes certain deprivations. But joining a military does not result in the abandonment of all rights, including the rights to a fair trial. Because military members come from all walks of society, injustices will be noticed. And while there may be deprivations, fundamentally, there must be fairness. When we speak about this movement in military law, there are certain people who would be on the, as we'd say in the United States, on the Mount Rushmore. One of those is Jan Peter Spijk, the former general in the Netherlands Army. Jan Peter was perhaps more responsible than anyone in his time heading the International Society for Military Law and Law of War, of bringing together people who cared about military law from all over the world to share ideas, promote their scholarship, and promote camaraderie. I salute you, General Spijk, and I'm glad to hear from you today. Another is our Mount Rushmore would be Eugene Fidel. Gene served as a judge advocate in the United States Coast Guard, and since then he has remained engaged in the practice of military law, always asking, why do we have to do it this way? And generally serving to expose times when military law was used to protect the interests of powerful military institutions rather than promoting proper values. And another one of Gene's important contributions since the year 2014 has been his development of the Global Military Justice Reform blog. You can Google that, Global Military Justice Reform, where Gene has taken a a gimlet-eyed review of military law developments around the world. If you are in a Malaysia or Nigeria or someone else, and you're thinking, "Gosh, something here is going on, and I don't think that this is right," there's a common community that you can find in Gene's blog, and he's already done some analysis on some of the things there. So that's very much a product of the movement, looking at certain principles that people in countries all over the world from completely different traditions that they believe in and they can find common ground for. And finally, I would certainly put Navdeep Singh on our Mount Rushmore. It helps to have a celebrity of Navdeep's status in taking a look at these things. And I came to appreciate that military law was indeed an international movement when I see him take on detractors within his country. Navdeep is good at promoting the nationalism in the positive sense of shared common purpose and unity, but also promoting those fundamental values of judicial independence, fair treatment, and basic human rights of its members. So ultimately, while this book considers the views of 25 authors from around the world, many of whom have never met each other, we had a lot of things in common. This ultimately comes down to Navdeep's idea to say, Frank, we know these people are out there. We know that there's a lot to be said and that there's a lot of common ground that hasn't been developed yet. Let's bring it all together in a book form. So Navdeep, over to you. Thank you.
Thank you, Frank. And Ankit, Frank has covered most of the ground, and he speaks for the two of us. And Ankit, you had asked me that what was the motivation behind the book. The motivation was very simple. The motivation was, as Frank also said, that there is no such book in the world that collates all milestone judicial decisions concerning the military at one place. So we just, Frank and I, we've been meeting at various international conferences and meetings, and thanks to Professor Fidel. And the first time we met was at the Yale Law School in 2013, and we immediately hit off because we share some common values. And the greatest value that we share is the value of justice in the civilian world as well as in the military. And so we just thought that if not a rare discussion, but it's a much ignored discussion in today's milieu, in the sense that we do speak about international law, we do speak about justice in the constitutional sense, but the kind of focus that should have been there on military justice and military law is not there. So we just thought that let's speak to our different friends all over the world who are dealing with the subject, and let's call for essays and commentaries from jurists and academics and judges from all across the world, some new friends, some old friends, and let's collate them in an easy to read compilation and anthology which even a layperson can understand and assimilate. So that was the aim. And we've received so many, you had asked us about what is the impact of the book. We've received so many messages from all across the world, especially from the nations of the contributors. And we've made, as I said, we've made some new friends, we've opened some new frontiers, and we have realized there are so many similarities in our systems as well as differences. And we can, pick up the best practices, and we can pick up the best of all worlds and improve our systems, within our respective nations. And future engagement will, I'm sure it will be definitely organic, and we'll take it as it comes. We'll let it run its natural course. And this eternal, debate between discipline and justice, which last evening I had the pleasure of discussing it with General A.K. Singh also, that this eternal debate whether discipline can override justice or vice versa. Both are very important. Discipline is the bedrock of any military. However, justice is as important because, contrary to popular perception, we feel, even Frank feels the same way, and most of the jurists in the world feel the same way in this field, that discipline gets promoted by fairness, by the sense of justice. You'll get a more disciplined military if you promote a sense of fairness amongst them. We have to strike a balance. Things have changed, concepts have changed. In 20, 30 years back, people used to say, oh, let's make an example out of this person. Things have changed. Now, the idea of justice is different, that let's be fair to a person, let's promote justice, let's promote the sense of equity, so that the women and men who defend our respective nations are even more patriotic, or even more attuned to their respective duties, and they'll perform even better when they are assured that yes, the system will be fair to you in case anything goes, if there's an issue on the military justice aspect of it, that the system will be fair. And we all strive to make the system even better. And we thought that the international community should get together and should talk about these points and improve our systems in a much more propelled manner.
Thank you so much. I deeply appreciate your comments and sentiments, especially the principle of equity. I think in the modern generation, the principle of equity is not given as much importance as it ought to be given. Equality seems to be the buzzword, but the explanation behind equality is rather pernicious and lost and muddled the ideas which were espoused by the founding fathers and mothers of the Constitution, the idea of the Constitution. To share his perspective on the chapter which he's devoted. I now invite our first speaker, Eugene Fidel. Sir, the floor is now all yours, please.
Thanks very much, and it's really a privilege to be with this group. I believe, in fact, I'm certain of this. Jan Peter, how many people are on active duty in the Dutch Armed Forces?
I think close to 100,000.
100,000. Okay, so I can say, therefore, that I'm the representative of the smallest armed force on this panel. Since my old service, the U.S. Coast Guard, which began as the customs collector for our under Alexander Hamilton and President Washington in 1790, now stands at about 40,000. But it's a service that, as we have the idiom in the U.S., that punches above its weight. So I'm happy to be the small fry among the giant forces represented here. I also want to say, just as a prefatory comment, the thing about military law is that if you put people who have been serving officers, military lawyers, uniform lawyers, in a room from a host of countries, you will find that they have more in common probably with one another than they may have with the lawyer in the next office suite in their office building, and with the judges before whom they appear. The issues do recur. There are common issues, and also let me say that I'm particularly glad that Jan Peter, I'm not punishing you here, Jan Peter. I'm not picking on you, but I think it's important that Jan Peter be on this panel, aside from his leadership in the international arena, because he represents a military legal tradition different from the Anglo-American Indian legal tradition that ties together a lot of communities around the world. So I think, you're here for diversity reasons, Jan Peter. You may not realize that, but you do serve that purpose. So there you have it. I want to make a number of points, and people will read my contribution to the anthology, and hats off, of course, to Navdeep and Frank for carrying this off. It's a lively book. I learned a lot from it. It was fun to write my own contribution, and people are welcome to read it, about a leading case that I had a role in. But I'm going to break out of formation here and talk about Indian military justice. May I, Mr. Chairman? Is that okay?
Please do, please.
I see General Singh has turned off his camera. So I want to make some remarks. And as Navdeep knows, these remarks are offered in all friendship, but I think the best kind of friendship is friendship that is built on candor. So with that by way of preface, I want to make some suggestions and raise some questions. As an observer, and I'm grateful to Navdeep and others to share information about current developments in Indian military justice. As an observer, it seems to me overwhelmingly clear that the time has come for a reform of Indian military justice. India is a major power. It has an enormous uniform forces of various kinds, not all of them, as I understand it, under the Ministry of Defense. And it is, speaking from a country that threw off the British yoke a long time ago, I think it's a country that has yet to get rid of some unnecessary and undesirable vestiges of the British Raj. I'll be specific. First, let me talk about the Armed Forces Tribunal. It took until 1982 for the Law Commission to recommend, or maybe it was the Supreme Court of India that got this started, to recommend the creation of an appellate court, so people didn't have to take every single case to the High Court. Well, how has that worked out? Parliament eventually created the Armed Forces Tribunal. The judgeships are split between administrative members and legal members. Legal members are all retired judges. That's good. It really, how has that worked out? My understanding is that for whatever reason, the government of India has found itself incapable of filling these benches. Is it because people aren't incentivized to take this responsibility on? Or is it because it doesn't pay enough, it's not interesting enough, people have other things going on? It doesn't matter. It's a denial of justice to Indian personnel, both active duty and veterans, retirees, if you have a court that in large parts of the country exists only on paper. I mean, this is intolerable. And I don't understand how a responsible government in a democratic country could permit a court system to atrophy. Paragraph 2, does the design of the Armed Forces Tribunal make sense? As Navdeep and Frank know, and I'm currently taking a very hard look at the arrangements that were put in place in the United States back in 1950-51, when we created a civilian court of appeals for the armed forces, now the Court of Appeals for the Armed Forces, formerly the Court of Military Appeals. Does it make sense to have a court with limited jurisdiction like that outside the regular architecture of the judicial system? I think people should be having that conversation in India. I don't have a solution. I know it's complicated. I know the American system intimately, and others know the Indian system intimately. But gee whiz, when you have a backlog that's over 10,000 cases, you might as well, that's a charade. And I know that the Indian Supreme Court has an enormous backlog. That's another problem that goes way beyond the immediate issue. Maybe in fact that drowns out any concern about this specialized court that has a few cases that doesn't affect everybody and so on. But honest to Pete, there's a problem there. I think turning to the trial courts, I think there's a serious problem with a system that is in large measure a relic of the British Army Act of 1885, 83, I forget which the year was. A country that's committed to the rule of law in this day and age has to have a functioning trial bench. And that has got to include people who are given independence, both in terms of tenure of office, protection from unlawful influence of whatever kind. And by the way, this is not easy. It's easy to say, oh yeah, you need an independent court. Countries grapple with this. The United States continues to grapple with it. It took decades, even after we created the military judge position in the United States in 1968. That's not ancient history, it's 1968. It took additional decades before Congress imposed, first the Army, did an internal reform by regulation, but before these judges had terms of office. They were at-will judges. I mean, for Pete's sake, you can't have an at-will judge in a hierarchical environment where everybody works for the same employer and expect to have public confidence in the administration of justice. As it turns out, I think there are serious questions about how the US system, what we settled on, which was we sold cheap, actually. So our judges have fixed terms of office of 3 years duration. And I'm here to tell you, I don't think you get an independent judge who has a term of office of 3 years. And by the way, who can be reappointed, because that person's going to always be looking over her shoulder, wondering, gee, I wonder if the center is going to reappoint me. So these are serious issues. Another issue, and it's related to the function of the trial bench, and I'll wrap it up with this comment so we have more time for discussion. But another issue, and it's still present in the US system, we haven't extirpated it, is the role of the commander. Over the last 100 years, actually, it's been about 100 years, we've seen a progressive diminution of the authority of what we call a convening authority, in favor of, in some respects, the civilian court that we brought in 1951, and effective the end of 2023, in favor of special trial counsels who will be lawyers with, for the first time, the power to decide who gets prosecuted for what, for certain kinds of offenses. It's unclear quite how much of the caseload they'll get taken away from commanders. But the notion that these inherently legal determinations of who gets prosecuted for what is being made by non-lawyers is just out of step, I think, with contemporary standards. So let me, I'll throw that out. There's a lot to chew on there, but I think and hope and I expect that we'll see an Indian Institute of Military Justice grow up that will be energized, that will be in the media, that will be on the evening news, that will be writing position papers, that will be appearing before parliamentary committees, that will be bothering people. That's our job, right? We're lawyers. And making some progress, because unless something like that happens, or you have a cataclysmically terrible outcome in a case that gets a lot of attention. That's the way the law does change in democracies. Unless that happens, I think India will have missed an opportunity. And I hate to see anybody miss an opportunity. This stuff is too important. So I'll close it there. Thank you very much.
Thank you for your kind words. I think all we need is an evangelist for the cause. And I think this discussion inspires one to take the lead and focus on these issues which impact the lives of so many others. I now invite our second author for this book, and also for the second panelist for this discussion. So the floor is now yours.
Well, thank you very much. And I'd like to start with giving a big compliment to the organizers of this event. I had a look at the complete series of seminars that you organized, and it's very impressive. So I'm proud to be part of this. I'm proud to be in this group of friends, because I know most of them already for many, many years. Compliments also to the editors of this great book. I can recommend it truly to everybody. It is a great overview of big rulings across the world. And as my good friend Eugene Fidel already said, one can learn a lot from reading this. I had the honor to contribute a chapter on a European ruling by the European Court for Human Rights. And maybe it is wise to just start with saying a few things about the European Convention on Human Rights, because that may not be familiar to all who watch here this afternoon or evening with you in India. The European Convention on Human Rights and Fundamental Freedoms, as the official title is a treaty in which the 47 signatory states of Europe promise not only to their citizens, but to everybody who is within the jurisdiction of the respective state, to secure fundamental rights, civil rights, and political rights. And I mention a few: the right to life, the right to liberty and security, the right to a fair hearing, a fair trial, freedom of expression, and freedom of thought, conscience, and religion. There are more, but these are the key ones. And the convention prohibits in particular torture and inhuman and degrading treatment or punishment, slavery and forced labor, the death penalty, arbitrary and unlawful detention, and the discrimination in the enjoyment of the rights and freedoms as set out in the convention. And in order to secure those rights and fundamental freedoms, the states, the 47 states party to the convention, agree to have a supranational international court. And that is the European Court for Human Rights, which has its seat in Strasbourg in France. It is an international institution with 47 judges from all the member states, appointed for a 9-year non-renewable tenure. Hundreds of thousands of petitions have been submitted to the European Court for Human Rights. And in order to submit a petition, and any individual in one of the member states or outside can do so, you first have to go through the national system of the state concerned. So you have to reach the level of an appeal or the Supreme Court where that is valid before you can make the step to the European Court. The case I will now briefly discuss is the case of Engel versus the Netherlands, 1976, an old case already by a conscript, a handful of conscripts at the time under the then military judicial system of the Netherlands, which led to a landmark case. And it is a landmark case because when reading this case, you will see there are a lot of principles laid out there, how to view a military legal system, how to view a judicial system in the military, how to weigh the punishments in a system like that. So highly interesting, I can promise you. And maybe a first remark is essential in that the court recognizes, and I read here, each state is competent to organize its own system of military discipline and enjoys in the matter a certain margin of appreciation. And this is interesting because when we look at military judicial systems around the world, not only in Europe, but also in the world, there are huge differences. No country is the same. I had the honor, as was mentioned before, to preside over the International Society for Military Law and the Law of War. And every country that I visited had its own system, which was different from any other system, to be compared with national anthems. Every country has its own national anthem and its own national system of military justice. They are all completely different. And that is the same in Europe. And it reflects the European history with common law countries, other countries, but for example, countries that suffered during World War II, you can see remarkable differences with military judicial systems, which are essentially civilian, 100% in nature, and in other countries where you will have a mix of civilian aspects and military legal officials, like in my own country, the Netherlands. Very interesting. So the court says every country may indeed devise its own military judicial system, but there are relevant boundaries. And the relevant boundaries have to do with the fact that by choosing a disciplinary system or devising a disciplinary system contrary to a criminal law system, the military may not escape, so to say, from the guarantees that the convention offers. The court is very clear in saying that the convention does not stop at the doors of the military barracks. It also applies to military individuals. But, and this is a very important statement, when looking at the rights and fundamental freedoms of military personnel, you have to take into account the special conditions of the military. So it's not the same. It is not translatable one-to-one, whether you're a civilian or a military individual. There are differences, but the differences do not go that far that the fundamental rights and freedoms may be excluded from military personnel. And when we look at disciplinary and criminal proceedings, it is noted that states have this freedom to devise the system, as I said. You will all know that there is this difference in terms of content. Generally speaking, disciplinary sanctions are less severe than criminal sanctions, often do not appear in the criminal record of an individual. But on the other hand, disciplinary proceedings often have less procedural guarantees for a defendant in a criminal proceeding. So therefore, the relevant question is whether a national decision to classify a proceeding as disciplinary as a consequence makes the right to a fair trial non-applicable. And this specific issue gains relevance when an act or omission can be treated as a mixed offense, both criminal and disciplinary, with the option of opting between or even cumulating criminal and disciplinary proceedings. And in the countries present here today, but also in all those other countries, you will see different systems. The court has developed what has been called now the Engel criteria, after the name of this judgment. There's three steps in analyzing this issue. Does the provision defining the offense charged belong to criminal law, to disciplinary law, or both concurrently, according to the legal system of the state concerned? More importantly, what is the nature of the omission? Does it contravene a legal rule governing the operation of the armed forces? And if so, in that case, the state may employ, in principle, disciplinary law rather than criminal law. And the last step is, the last question, what is the degree of severity of the penalty the person concerned risks incurring? And the court notes here that certain deprivations of liberty imposed by way of punishment belong to the criminal sphere. And the duration of the deprivation of liberty is an important indicative factor in this respect. I'll come back to that in a moment. Let me move on to a topic in this judgment which requires mentioning, which is the issue of inequalities of treatment between servicemen and civilians. Because the plaintiffs in this Engel case complained that military individuals, conscripts, but in general military individuals, were treated more severe in the disciplinary system than civilians. And the court says, well, when the convention was drafted in the 50s already then, and that situation has not changed, the states possessed defense forces. And in consequence, all these defense forces had a system of military discipline that by its very nature implied the possibility of placing on certain of the rights and freedoms of the members of these forces limitations incapable of being imposed on civilians. So the existence of such a system is acceptable. It does not run counter to the convention. So there is no discrimination incompatible with the convention, the conditions and demands of military life being by nature different from those of civil life. I propose to now turn to the issue of deprivation of liberty in the context of military service, a topic the organizers of this seminar asked me to specifically address. And then I'll close after that to have, so that we have more room for the discussion. As I said, a system of military discipline implies by its nature the possibility of placing limitations on certain of those rights and freedoms of the members of the forces. It does not run counter to the obligation of the contracting states. And in order to determine whether someone has been deprived of his liberty in the sense of the freedom of liberty article, the starting point must be the concrete situation. And the concrete situation is, how are the things organized within that military specifically? And deprivation of liberty, to make it completely practical, can be to detain an individual, a soldier, a corporal, an officer, within a kind of a cell. And the court says, well, if that detention is very much alike to a prison facility, then the right to a fair trial should be respected. And that means that a court, an official court, should rule on the issue and should give a sentence. You may detain a military individual in the barracks, for example, or in a certain building or in a certain room, but it must not be like a prison, because normally military personnel is not incarcerated, to use that word. So one cannot have the argument, this is normal within the military. When it is a prison-like facility, then there should be a court which imposes a ruling. That is, in short, the standard that the court requires. The same goes, for example, with the issue of freedom of expression. Everybody under the convention has the right to freedom of expression, orally or in writing, but military organizations may put in place limitations on this right, because the military has its own specific order. And given that specific order and the interest of the state to have a coherent and effective military, there may be limitations on the right to offer your opinion. Because it cannot be the case that military individuals create havoc, so to say, within the armed forces. I'd like to stop right here. There are many other issues in this very interesting ruling by the European Court of Human Rights, but I do look forward to the other presentations and to your questions. Thank you very much.
Thank you so much, sir, for those enlightening words. And as a personal project of mine, which I undertook last semester, I prepared a presentation in the court and its jurisprudence, but focused from a historical perspective on how it started after the Second World War and the instrumental role Sir Winston Churchill played in inaugurating, or at least instilling, the idea of a European Charter for Human Rights. And this is a sort of a private undertaking of mine, but it's been congratulated by the Churchill family as well. So I do understand, but I'm also worried about the inception of such conventions. Does humanity have to reach such a level to then look into its conscience and decide this is the very appropriate time to have a convention on protection of human rights? This is the century of human rights after all. Why are human rights not placed at the forefront of the human consciousness, especially in times which test the mental strength and grit of all human beings? I now invite Professor A.K. Singh to share his comments in the books and also the remarks made by the panelists in this discussion.
Right. Thank you. Ankit. My salutations to all the very distinguished panelists. And this is the book, and I would strongly recommend this book to everyone. I wish I had recourse to this book when I was in critical positions in the army. It would have been a help to understand the nuances of military law. Okay. I was asked by Ankit to critique the speakers and also do some book reading. I think critiquing the rest of the speakers is beyond my intellectual capacity. You are distinguished in the field of law. I'm a practitioner, because of the job that I did, a command responsibility. And therefore, I had to mete out military justice when I was commanding my unit, the brigade, the division, the corps, and finally the Southern Army, where I had 42% of India with me, my responsibility, and about 300,000 troops. And there were many instances where I think I would have been wiser had I had recourse to such a book. So my compliments to both the authors for having taken out this book, and I will also try my best to recommend it to the armed forces so that people can appreciate what is happening around the world, and also appreciate that while our system is fair to an extent, but there is always scope for improvement. And I think sooner than later, some improvement has taken place, but more should happen. I will just raise a few issues, but before that, just a word about what is common to the armed forces and which is universal. And I think I would point out two issues. First is the linkage between responsibility, authority, and accountability. I don't think it exists in any other profession in the manner that it exists in the army or in the armed forces. If you have responsibility, you are given authority. And because you have authority, you are also accountable. Now, this accountability also is nuanced. Your first accountability is to your mission. And we all understand how critical such missions are. And therefore, you need to be responsible for the mission and the team that is performing that mission. Only then comes the individual. So we have to understand this linkage in the armed forces. The second is that you have to ensure just discipline and justice. And the two are, I won't say interdependent, but for the commander who has to ensure discipline and when the time comes, also give justice, to say that he can compartmentalize his mind to separate the two is sometimes challenging. Sometimes acts of discipline come in front of you which have a wider connotation and whose ramifications would go far and beyond. Also, the aspect of discipline and justice in combat situations requires sometimes justice to be delivered in a faster time frame than would be the norm or would be acceptable in normal peacetime. But let me say, in India, I think we were a very close system and we carried on as we had inherited from the British times. But of late, after much efforts by people like Navdeep, changes have come about. and we have the Armed Forces Tribunals. They started off well, but there is a slag now, and I'm sure the sooner that the government empowers these Armed Forces Tribunals, the better. But why talk of only military justice in isolation? I do understand that this book is about military justice. But especially in India, we have to understand the larger construct of justice. Let me say the population or the people in India, by and large, hold the judiciary, especially the higher judiciary, in a higher credibility than many other institutions. But that is sometimes fraying on the edges. And off and on, we do come across such cases which impacts this credibility. Some of those issues have been highlighted by Jan Peter, and we will discuss more of these. But you'd be surprised to know that in India, to get a case listed sometimes takes years and years. Forget the processing of the case. Can the military in India afford to have a portion of this kind of judicial system transferred to itself? You know, one of the critiques of the military judicial system was that the same person who was the commanding officer, the convening authority, also sat in judgment. So this was challenged in a case in UK. I think it was called, case of Lance Sergeant Findlay, who actually challenged this, and he didn't get justice in UK, right up to the House Appellate Authority and even House of Lords. So he went to the International Court of Justice, and there is some damning observations, and the Ministry of Defense in UK had to take certain steps, but they took the minimum steps. But one major change that came about in 1996 as a result of this was that the independence of a convening authority was ensured by appointing independent personnel who would then act as the convening authority and process the military justice system. There are merits in that case, but I'm not so sure if this is a universal route that would be applicable everywhere. I think Navdeep would be best because he has seen the system in India. Should we move on this trajectory, or should we keep the system that we have inherited? Now, these are some of the issues. I remember a case, prejudging a case. I was commanding a strike corps, and I get a call from my superior one day to say that so-and-so unit has come and there is a lot of indiscipline going on, and he was castigating the commanding officer. And there were some serious breaches. And by his tone, it looked as though he wanted me to set an example of the commanding officer in a very short time frame. So I told him, and this had not even been brought to the military court stage. It was the preliminary investigation. So I visited the unit, and I realized the special circumstances. That unit had just come from Kashmir, and there were legacy issues that they were carrying forward, and they had come to central India. I then went into the depth of it and realized that it wasn't this commanding officer's fault, because he had just come to the unit after it had landed. But that's how the military system works. So I had to put my foot down and say that we will deal with the individual cases, but we will not take it as a general indictment of the whole unit. And I dare say that commanding officer today is a general officer. But in our system, the way it works, it would have actually resulted in a prejudged mind of the people who were responsible. So let me say, how fair is this system? Are the people who are, I put down a few, yeah. Discipline versus justice. How fair is it? I would say, at least in our case, it's mostly fair, but to say that there are no pressures and no biases would not be correct. There is no question that these things do exist and we have to accept them. Are the members who form the military justice system in India qualified to give that justice? You know, we all are educated in military law, and we have to pass certain promotion examination where military law is a subject. Having said that, I would qualify it by saying we may be educated, but not everyone is qualified. This is how I would summarize. We may be educated, but not everyone is qualified. And the last case that I wish to say is, do we have independence from the system when it comes to the court martial or military justice? Can it put a vertical between his normal routine job and what he's doing at the court martial? He's supposed to do that, and that is how it should function. But I'm afraid that that may not be the case all the time. So I think there is scope for reform in the military justice system in India as we practice it today. And I think this book is a very fine example of how some other countries have tackled with this very same issues that we are confronted with today. So I'll rest my case here, Ankit, and we can discuss some of these issues with the co-panelists.
Just one brief comment. I think the book, even before it starts, shares the Dreyfus trial, and I think that summarizes, gives a good description of where the authors want to take this. I show it up because it's an instrumental aspect or the motivation which encourages the authors to undertake this study as well. I'll encourage everyone here. We have a photograph also with the book in the end, but before we proceed further, I'd encourage discussion and I'd encourage well, I was supposed to encourage Professor Fidel, but I think he's going to look for the book. I encourage Major Singh and also to Professor Rosenblatt to share their comments on the discussions raised by Professor Singh. We can't hear you, sorry.
Yeah. This is the one illustration in the textbook that Frank and I and a number of others have put out on military justice. This, of course, is a painting of the United States' last monarch, George III, and our system, like the English system, like the Indian system, is a legacy from George III. So the picture in the front of the book is often worth the price of admission in itself.
There's a wonderful account by historian Andrew Roberts on George III, who says that George III, after all, wasn't that bad at all. He's also, in fact, touring the US. But let's return to this book and encourage discussion. Professor Fidel, would you like to, since you're the nexus point for this book and so many discussions around the military justice system, I'd be very interested to hear what you think about the points raised by Professor Singh.
Was that to me?
Yes, it is.
Yeah. Well, my own view is that military justice systems, and I think the Indian system is probably as good an example as any, are often going to get it right. in the same way that a broken clock is going to tell the right time twice a day. The whole point is that the system should be one in which everybody can have confidence in the administration of justice. Otherwise, does India have conscription? Yes.
No.
No conscription. No. Well, all the more important then, because if you have a non-conscription environment, then the national defense depends very directly on public confidence, because otherwise people will vote with their feet. They won't sign up unless they're, really in need of employment or whatever, or education, the other things that incentivize people, or, are simply extremely patriotic and a country may be under pressure externally. But really, you cannot, in a democratic society, you cannot, that does not have conscription, you cannot maintain a viable national defense without people feeling that they or their loved ones are going to be treated properly and fairly all the time, not twice a day. So that's sort of an overall comment. One thing we haven't talked about, by the way, and I'd be very interested in people's views on this, is getting what in the US is called the purple system. In other words, a single system of justice, a single statute that affects all the armed forces. Interestingly, we refer to the Uniform Code of Military Justice, the UCMJ, but even though it's a single statute that replaced the various statutes that affected the Army had the Articles of War, the Navy had something else. The services remain remarkably autonomous, in fact. And yes, our Defense Department plays a very minor, I think this is fair, a very minor role in keeping these horses pointed in the same direction. So it is a uniform system, sort of, but it is not a unified system, except when you get to the very top, the Armed Forces Tribunal or Court of Appeals level. So I'd be curious, is there a move to have a tri-service or however many, I mean, the Indian Coast Guard should be brought under the same statute as well. Is there a move in this direction?
There is a move on paper. There is a move on paper, but not a serious push enough. We've just instituted the system of a chief of defense staff recently, and tragically, we lost the first incumbent in a helicopter crash, as you know, Professor Fidel. So there was a committee of experts of which even I was a member. So we had recommended the same, that there should be a Common Service Act. And you and I had also written an opinion piece on it, if you remember. So,
yes, I do.
Yes. So the move is there on paper, but it is not getting a very serious push. But I'm sure it will. We will move towards a purple system once, the CDS has just been incepted. So over the next few years, I'm sure there will be a move, and taking care of specific service requirements. You can have a system inbuilt in the Umbrella Act for separate aspects if the services so desire. But I'm sure there will be a purple move towards military justice in the near future. And as far as the reform of Indian military justice is concerned, I would say that it is not that people do not want reform. And I would also say that, as I always say in such discussions, that the system is not draconian, but the system is outdated in parts. The first thing that we need is an independent prosecution, director of prosecution, as General A.K. Singh also said, that's a very major piece of reform, that people, firstly, the prosecution has to be independent, the prosecutorial independence has to be ensured, and the people should not be associated with the criminal infraction, and the chain of command should be a little aloof from the entire setup. And I see again, it is not that there has not been judicial intervention. There have been changes that within the current system, within the current statute, because of judicial intervention of the High Courts and the Supreme Court, there have been many changes, many positive changes. There has been a change in attitude also, and I'm sure the system would reform in the times to come. But again, there is not a major push because militaries tend to be a little inward looking all over the world and a little resistant to change. So that push does not seem to come from inside, but I'm sure through courts, through thinkers, through influential retired officers, veterans like General Leke Singh, and various committees, parliamentary debates, things will move ahead. The process is slow, but I'm very positive about the future because things are not that bad. But as far as the independence is concerned, Findlay's decision and John Rue's decision by the Supreme Court of Canada, those kind of changes we do require. And as far as the Armed Forces Tribunal is concerned, I also share your concern that it is currently understaffed, but that is not just restricted to the Armed Forces Tribunal. What happened was that there was a legislation in India which attempted to take away the independence of all tribunals in India. That was challenged in the Supreme Court. It was struck down, but the government again came up with a legislation which was a mirror image of the earlier legislation which had been struck down by the Supreme Court. So that challenge is again continuing. It's again in the court, and the slow appointments are a result of that litigation which is pending. However, it is better to have, it is better to wait to have a better system in place than to appoint people in a system which will not be independent. So that it's very chaotic. It's very difficult to explain the total chaos and the utter chaos that has been caused in the issue. But I'm sure things will, things will move in a positive direction once this issue is again resolved by the Supreme Court. And again, it affects all tribunals, not just the Armed Forces Tribunal. And now the Supreme Court has ordered that the parent administrative ministries will not have control over specific tribunals. Right. For example, the Ministry of Defense should not have control over the AFT. The telecommunication ministry should not have a control over the tribunal which is dealing with telecommunication disputes and so on. So once that happens, things would be much better. It is not that there is a dearth of applicants. There are many applicants, there are many people willing to join these tribunals, but the slow appointment process is because of this. And the number of pending cases is even above 15,000. It's not just 10,000, it's above 15,000. So it's a huge backlog. But India has a very low judge to people ratio, judges to citizens ratio. And we have a huge system of, we have a huge problem of backlog in the entire judiciary, not just restricted to the AFT. But there are many vacancies, and again, there's a tussle at times between the judicial setup and the executive, because judicial independence is very precious to the Indian Constitution and to the Indian citizenry. And we can have backlogs, but we cannot, have a system which is not independent. It is very, very precious to all of us.
I want to interject, if I can, and get other people's reactions to this. We have a hot issue right now in the United States. It's what I call the vaccine mutiny. We have military personnel who, some percentage, it's small, but it's real, who don't want to get shots, including people who say that God has spoken to them at night. I'm not making this up. People who claim that, they've heard a voice at night and it's God and telling them don't get the shot because whatever. And we have, this is current events. This is in real time, as Frank particularly knows. We have federal courts, including many judges, speaking of judges, who were appointed by our last unfortunate president, who have basically supported the vaccine mutiny and have prevented the Secretary of the Navy, for example, from firing the commander of a ship, a Navy ship, who is an anti-vaxxer. We have the court saying that officer's religious freedom trumps, forgive the expression, trumps the Secretary of the Navy's authority to say who is going to command a naval unit. And this is madness, personal view there. I'd be interested in, whether anything like this has shown up in other systems.
Yeah,
Gee, not in India. We haven't had vaccines have been compulsory in the armed forces, and all eligible people were given dates and periods in which they had to, and it hasn't become an issue. There may have been one odd case, but it hasn't come to my notice. So we have been spared this, but I agree with you that this is madness, because that commanding officer of the ship, during a period of when the infection was very high, he would infect his troops. Now, how do you have troops who will not go in front of the commanding officer, knowing that he's not vaccinated? He could infect them. And this is where, well, the Supreme Court has laid down, so I don't know what can be done about it. But there is a very interesting thing. Navdeep, is there this summary trial and summary court martials prevalent in other armed forces also, or is it peculiar to us?
No, they are present, sir, but in a different format. And because summary, I mean, it's a big controversy in the US also. And Professor Fidel and Frank have written about it. And we had, in fact, we had a seminar where we discussed this in great detail. But again, in our country also, sir, the summary court martial, it has been toned down a bit, and it has been made more judicious by the Supreme Court that employ it only in a dire emergency, and wherever an urgency of action is required, and ultimately, or try to take administrative measures rather than a summary court martial.
Right.
So, yes, sir.
And this holds particularly true of combat situations.
Right.
And Jean, have you had any controversies in your deployments in Iraq, Afghanistan, and the meting out of military justice there? Has there been anything noteworthy that has come out from those areas?
Before we go to Professor Fidel, I'd just like to invite Brigadier General Spike to speak, as he wanted to raise a point as well.
Yes, thank you. Well, first, in reply to the question by our friend Eugene Fidel, no, we had a few cases, I think, where military personnel did not want to be vaccinated. We do have a general obligation for military personnel to be vaccinated with whatever vaccine is necessary to deploy. There is an objections clause, so to say. Religious issues may play a role, but only to a certain level. As soon as it, let's say, impairs the ability to deploy a military individual, there the buck stops, so to say. So as soon as there's a risk to his fellow soldiers, because he or she is not vaccinated, then eventually the individual will be dismissed, indeed. Yeah, that's where it stops. Yeah. And I'd like to thank General Singh for raising a couple of interesting points, especially the Findlay decision. Thank you for mentioning that. That's also a benchmark European court case where the independence of the prosecutorial service was laid down. And here we see an example. Same happened in the Netherlands with the Engel case, but here the European Court overturned, more or less, George III system in the UK. They had to completely remodel their military judicial system to be in line with the procedural rights and freedoms and guarantees as guaranteed by the European Convention. But that for the moment. I may speak later maybe on the extraterritorial aspects of the convention which deals specifically with the point that you made, General, on authority and accountability.
But let me just encourage you to do that, because that's an area of interest to me as well, and then we can segue that and invite Professor Rosenblatt also to comment on that. So, Flo's still with you.
Okay, well, thank you very much. Well, a big issue with the European Convention has been whether the Convention only applies to the territory of the states concerned, so that is in Europe, or whether it is possible that the Convention is also applicable in terms of guaranteeing rights and freedoms outside. And the latter has been the case in relation, there are several cases, but the military cases are most interesting for us, I think, where contingents of troops have deployed from European states to other nations. And the big example here is Iraq, where both UK contingents, Dutch contingents, American contingents, but not relevant for this discussion, were deployed. And where I'll take the case of Al-Shkaini and Al-Jeddah, two famous UK cases, and the case of Jalud, a case where the Dutch military was. And the central element here is that the military force abroad in that foreign country executed control, so to say, not only over an area territorially, but also over people. And they, in the words of the European Court, they executed governmental functions, governmental authority. So when it was the case that people suffered from the treatment by that military, people were killed, actually shot, mishandled, etc., they filed a complaint with the European Court for Human Rights. And the European Court said, yes, the UK government, or in the other case, the Dutch government, was indeed responsible for mishandling that situation. And they have to pay damages to the family of the deceased. And that ties in completely, General, with your earlier point in the beginning about responsibility, authority, and accountability. Because these rulings show that the officers in place they are responsible for maintaining standards with regard to the physical integrity of the local population. You cannot just do what you want. These standards of fair trial, etc., and the right treatment and the right to life should be respected. That's what I would like to say on this. Thank you.
Thank you.
But I just want to have that juxtaposed against these peacekeeping forces which are also sent. Of course, the mission and the aim is quite different, but those come with certain privileges and immunities. This is something which I found striking in the chapter as well. That I'll be interested to know more about this, claims which come against these officers from European nations with respect to their involvement or their being in foreign nations like Iraq, and how does that play out?
Yeah, well, the immunities that you mentioned have probably to do with the status of forces agreements that will be concluded when on a peace mission, for example, a national contingent is being deployed to a third country. And one of the elements of such a status of forces agreement is normally that the individuals of that contingent shall not be held criminally accountable by that country. So they are immune from criminal prosecution in that specific country. But they are not immune from criminal prosecution by their own authorities. That is one. And the second element is that that country under the European Convention remains accountable and responsible for misdeeds, wrong acts committed by its military personnel. So these immunities, not to be prosecuted by that country where the peace mission is operating, will not mean that they can do whatever they want. Certainly not.
It
Does
bears a lot of,
that answer the question?
yes, it bears a lot of resemblance to the diplomatic and consular immunities which are offered.
Yeah.
And let me now turn to Professor Rosenblatt and seek his comments or opinions on this, and whether in his experience he's come across certain issues pertaining to this aspect.
Thank you, Ankit. I wanted to pick up with a question thrown out by General Singh at the end. In the United States, we have now 20 years of some lessons learned the hard way about the application of military justice as it pertains to military operations. So I'd like to very briefly offer 4 recollections. First is that there is a lot of domestic pressure to when people are charged and convicted of atrocity crimes to let them off the hook. We have pardoned some soldiers who committed serious atrocities against civilians and who were held accountable in the military justice system, and that has a very deleterious effect on morale and I think the fighting effectiveness. And second is when you send your forces overseas to a country that's far away from your home, it's often difficult to take the mechanisms of justice with it. It is important to do so, but that requires mainly an appreciation for the importance to take justice wherever the soldiers go. The third is the need for fulsome and intellectually rigorous investigations. For example, in the Abu Ghraib scandal, which continued to plague the US military for years, one of the reasons why it plagued was that we prosecuted 6 lower ranking soldiers and said these were the bad apples. And we never really took the steps to say what were the real causes here and you know, who was at fault, regardless of at what level they may have been at. And finally, we're increasingly seeing in some recent scandals in Afghanistan and Syria, the need for accountability when it comes to acts of negligence. Often this is negligence that results in the deaths of civilians. And now the militaries may say, well, that's not per se a war crime because it wasn't an intentional targeting of civilians. But I think you find that the operational accountability and accountability in some sort of military justice or civilian forum for whatever acts of negligence happened, that at least deserves to be on the table and not ruled out just because it may not have been an intentional act.
I think, Frank, that last issue that you have raised is something that has been on our minds too. In the Indian Armed Forces, we are very quick to take cognizance of any acts which are done with a willful purpose, or any acts of misdemeanor, personal misdemeanor. Okay, but this question of acts of omission and commission resulting out of negligence, and if you stretch it further, even incompetence is something that most militaries do not take cognizance of in the right spirit. And let me give you an example of the American Armed Forces. You know, in the Second World War, any general who didn't meet the standards was sacked. He was sent back to some insignificant job. But since the war was 4 or 5 years duration, he had a chance to come back and redeem himself. And a lot of them redeemed themselves. But after the end of the war, going towards Vietnam and so on, Korea, Vietnam, the American Army stopped holding its senior generals to account. And that led to the debacle that happened. One of the reasons, there's a lovely book called The Generals. Yes. I think it should be a must read for everyone. And they had to re-establish this accountability. And this is something I've been trying to propagate in the Indian Army as well, that we need to hold people to account for acts of negligence and acts of omission and commission resulting out of sheer incompetence. Right? You just can't say, so yes, one understands that you take action in good faith. Some will go right, some will go wrong. That's different. But a guy who's negligent of his duties, I think needs to be brought to book somewhere or the other. So it's a question that is confronting most armies, at least professional armies are confronting.
Please, sir, please.
Yeah, well, related to that, and thinking of the operational mishaps that Frank has referred to, is the question of transparency. Even in countries that have a strong tradition of open government laws, freedom of information, access to records, transparency may be, I'll say, the second casualty of war. Governments do not typically fall all over themselves to share bad news. We've seen repeatedly, I'm talking about the United States here, operational mishaps that to which the authorities present a very partial, incomplete account that turns out usually, or I'll say from time to time, thanks to the media and their ability to really drill down, to have been incorrect or to have, finessed various unpleasant facts. And I think that transparency is going to continue to be a problem because armed forces, ministries of defense, defense departments don't particularly like to broadcast their failings. And, the consequence is just like not firing generals. And General Singh is absolutely right. The book is by Tom Ricks, and it's a wonderful book. Yeah, exactly. It's a fabulous book.
It's a fabulous book. Navdeep, try reading it. You'll get a good idea. And I think when I read this, I said, there's so many similarities that you can identify with your system. Our 1962 operations, the only time the Indian Armed Forces did not do their job properly, it still haunts us. And I think,
Of course, the other side of the coin, there's always an on the other hand, right? We know this. The other side of the coin is that from time to time, commanders can get fired for reasons that make no sense at all. You can get fired for essentially political reasons, or because somebody's looking for a scapegoat. And commanders, and this I think will never change. Commanders actually don't have tenure in office. It's probably the toughest job in the world to be a military or naval commander, because at the end of the day, it's like, what we in the United States call a political appointment. Your heads can roll, and you really don't have any rights to be a commander. And sometimes, and I've advised commanders, I've represented commanders, sometimes there's just literally nothing that can be done. You just suck it up and go into retirement or whatever. And I think this is a part of life. And I've got reform solutions for a lot of things, one or two of which may work, but I don't have a reform solution for that.
We have that in the Dutch personnel regulations, that general officers can be fired at the spot without giving a reason.
Right. And you actually, if I were king, I think I'd want that as well. If I were a minister of defense, I'd want that as well. I'm sorry, you're out.
The pleasure
Goodbye.
of the president. Yeah. The pleasure,
Well,
Doctor.
Well, we're closing in on time. In fact, we're already over. So let me just invite final words from everyone, and then we can close. So we start with Professor Singh, and then we can all have a final word. Professor Singh, final words, please.
Right. Let me say, I was slightly not overly enthusiastic coming amongst this panel because each one of you is a landmark in yourself. And frankly, while I have been at the cutting edge of many, many tricky situations, I do not have mastery of the law as you would have. But when Navdeep, I haven't been able to go through the whole book, but I picked up certain chapters that interested me. And I found that it sheds a different perspective. Frank, I think it's a lovely book that should be background reading for most people who deal with military law so that they understand. It will probably help them do their job in a more judicious and fair manner because they would know that it is something on which there is a spotlight. May not be today in our country, but it will happen in the future. So thank you both for this lovely book. And I must particularly thank both the co-panelists, Jean Fidel and Jan Peter, for your enlightening views on many subjects and some tricky subjects. And we still haven't come to a conclusion. Should generals be fired on the spot or not? And Ankit, finally, thank you very much. I feel proud to see my student on the right path. Thank you.
All your grooming and your blessings, which will take me and so many others who you've taught over the years to different heights and will make you proud. I now invite the other Singh on the panel to share his final words, and then we'll go to his co-editor. So,
Well, Ankit, first of all, I must thank you for bringing us all together. As I said that, in the journey of this book also, we've made some new friends, and I'm glad that we could all come together and I could introduce Frank, Professor Fidel, General Spike to you and also to General Singh. And it's so great. I mean, we can always, even if we come from slightly different fields, we can always put our heads together and it's all in the service of the society. There's nothing commercial or financial to gain as far as all of us are concerned, but it's always good to put our minds together, serve the society, and reform and march on and march towards justice. And as you may have also realized that especially in democracies, the issues that confront us are almost the same. Our values are almost the same, and it gives us great pleasure to hear different views and different viewpoints from all democracies and come together, put our minds together, put our heads together, and ultimately serve the society to our best possible capabilities. Thanks a lot, Ankit, for bringing us all together.
Thank you, sir. Professor Rosenblatt, please.
We are grateful for Jan Peter's explication of European approaches. Jean Fidel's, as always, provocative challenge for the Indian military justice system to do better. And General Singh, I especially enjoyed the wonderful exchanges with you and your approaches from many different angles and perspectives on the issues of the day. As for current events, if you're like me, you've been glued to the coverage of Russia and Ukraine right now. And this is often talked about in terms of, can they invade? Can they fire artillery into cities? All these other things. And I think that looking at this in terms of military law and tribunals is a helpful way to think about this. Who is doing something? Is someone responsible for this? Is there a meaningful way to address this, not just within tribunals, but like what General Singh was talking about? Does a general just need to be fired? So with that, I thank you all.
We'll now quickly turn towards the authors of chapters for this book, Professor Fidel, and then we'll have the final word, sir.
Well, I hope that this book makes Navdeep and Frank rich men. I hope it sells millions of copies, millions.
That's not the aim, actually, sir. Never had that aim.
But in all seriousness, I will say no one ever got rich writing a book about military
That's
law.
right. I mean, people.
That is a fact. However, I know it is people in leadership positions in the armed forces around the world sometimes come up with lists of books that they think their fellow officers should be reading, recommended or required reading. And I would say this is a book that should be required reading. And I hope that military leaders put it way up at the top of the queue because there's just so much of value in it. It's a fascinating book. It was fun to write for. It was fun to read other people's contributions. And I really am grateful to be included in this posse.
Thank you. So, final word, sir.
Yes, thank you very much. My compliments to the organizers for this event, because both the book and this event reflect, I think, the necessity to look over your own borders, to this willingness to learn and the willingness to change. And it's by doing so that we can move forward and we can do better also in military justice. And so that's what I hope. And certainly, let me just add to Frank's words on the Ukraine. We didn't discuss international humanitarian law this afternoon. Maybe this is a suggestion for another seminar, because one of the important tasks of the military in operations is to respect those basic values of the distinction and humanity, and that should be done everywhere at all times. Thank you very much for letting me join in.
Ankit, I don't know whether you're aware that General Spike is the honorary president of the International Society of Military Law and the Law of War, which is very, very topical today for what is happening in Europe.
Sure, sir. And we must come together, as was said earlier, to bring our minds together and work on issues which require immediate assistance. And I will keep in touch, and we must do something on that as well. Before we close, let us just put our books up so that I can take a photograph, and then we can share this later on as well. But sir, I will request you, Navdeep sir, to take the photograph if you can, or should I from my end? Because I'm on a... Okay, wait. Then I have to pull it up and also see how if I can do it with one hand.
Mine is in another city, so I can't hold it up.
But you're there, that is good enough.
Just hold up a copy of The Generals.
Okay, thank you. Thank you, everyone. Thank you. Thank you. Thank you, everyone, for joining. Good evening. Thank you very much.
Thanks a lot.
All the best. Thank you.
Bye, everyone.
Good night. Thank you.
Bye-bye.